credit for attending. We have applied for and anticipate approval for 6 to 6.5 hours for Minnesota and 7 to 7.5 hours for Wisconsin. The Kinney and Lang website includes information on credits allowed in previous years as well. So now that we've gotten the administrative matters out of the way, on to the presentations. First, we have Alan Koenck, who is a shareholder at Kinney and Lang, and he will be speaking about important things to remember under the America Invents Act.
Thank you. Thank you, Katie. Let's move this down a little bit. Good morning, everybody. Glad to see you here bright and early this morning. I did hear the announcement about only water in the auditorium, so I will be completely understanding if any of you get up and grab some coffee at any point during my talk. It's pretty early, so, but it's great to see this many people here. Also, one thing that we are starting a little earlier this year than normal, for those of you who have been here before. And of course, part of the reason for that is so that everybody will be able to get out of here a little sooner as well on a Friday afternoon. So we'll be done by 4 o'clock today. Be curious to get some feedback from you as to whether you like that schedule or you think this is maybe a little early. So those of you who are here, I'm sure, are probably the ones who like the schedule. Those who kind of filter in a little later, maybe not so much. But again, it's great to see you. I'm going to just ask a couple of questions to get an idea of our audience here. Just out of curiosity, how many of you, is this your first time attending a Kinney and Lang intellectual property seminar? Oh, great, lots of first-timers. So, and who has been here one or more times in the past to our seminar? Great. All right, well, one more kind of demographic set of questions. How many of you regularly practice in the area of patent law as part of your practice? Okay, and how many have rarely, if ever, done any actual practice in patent law? You're just kind of here to learn about it from the outside. Okay, good. Well, I like to know that information because I'm going to give, and our seminar is kind of unique among a lot of intellectual property seminars that you might go to, in that it's not just tailored for patent practitioners. We certainly have some issues that are very specific and detailed about the practice of patent law, but we try to present those in a way that for those of you who don't practice it every day, it still can be useful information. You can learn some of the background behind what these issues are really all about, and we'll try not to dive kind of straight into the issue without giving you some context for what's involved, what that's about, and why we're even having a discussion on some of these issues. So that'll be kind of the approach I'll try to take as I explain to you guys what the really important aspects of the changes under the America Invents Act were about. I've spoken for those of you who have been here before, you've probably seen me talk about patent law reform or patent office rulemaking changes multiple times in the past. And usually the talk goes something like, well, there's a proposal for patent law reform, and well, there's lots of really interesting things in it, but these things never pass. They always seem to kind of get bottlenecked and don't make it to actual law, and so it's an interesting academic discussion, but there's no sign that it's going to be here anytime soon. Well, for the first time since 1952, a major reform in patent law actually happened, effective kind of at various dates, but the last provisions went into effect this March. And so we are now under a very different regime of patent law, and there are some significant changes that have changed the way, for those of you who do practice patent law, that have changed the way that we have to approach a number of things. So I enjoy topics like this. There's a couple of reasons. One reason is that there's lots of time to prepare, because congressional action usually takes a long time. You can really see it coming from a long ways away. So we don't really have the issue of, like the person this afternoon who's talking about Supreme Court cases had an interesting day yesterday, because there was an intellectual property decision that came out from the Supreme Court just yesterday that he'll be talking about today. So I don't have any concerns like that in my talk, which I really, really appreciate. And the other thing that I like about this talk is that it's something that I work with kind of on a regular daily basis. This is really, the things that I'm going to be talking about in the AIA are the things that affect what I do on a day-to-day basis. And so I feel like I get a chance to kind of give you an insight or a window into what our patent prosecution practice is like at Kinney & Lang. And in fact, just so we could give you a sense of what that's like, we had some of our summer clerks kind of go around the office and try to get a picture of some of us, kind of a typical day of practicing in our office. And so what they came up with was this shot of us right before we were really going to work hard on something related to the AIA. And so actually this is probably what we think about all the time, but maybe not what we do day to day. So with all that said, let's try to go through what the major changes to patent law were under the AIA. For patent attorneys who have been kind of living this day to day like I have, most of the information here will be things that you are aware of. This will be a review of things that you're already doing. And for those of you who don't practice in this area, a little bit of an introduction as to what patents, what the rules and regulations affecting patents and how they've morphed as a result of this legislation. So this is kind of a highlight list of the changes from the AIA that have had kind of the most effect on how patents work. And the first one is the one that got by far the most press and is the most significant change to patent law that came from this, and that is dealing with the issue of who has priority for multiple inventors that come up with similar or the same thing. Who is able to get priority in an effort to get a patent? A patent, of course, being a right to exclude others from practicing your invention. So if you are first and are able to get a patent, you can prevent the rest of the world from practicing your invention. That's really the whole value of a patent. And so priority is a pretty important thing when there are conflicting inventors. And the AIA changed the rules behind this to a system where priority was given to the first to invent an invention, meaning that they either conceived of it first and then reduced it to practice, but had the first conception, or that they were actually the first to reduce it to practice as well, kind of irrespective of the filing of a patent application in some situations. We'll talk about this a little bit more detail later. But inventing was the key action here that gave you priority. Under the AIA, that changed to be a system where the filing date of your patent application became really the key indicator as to whether you would be given priority over a conflicting inventor. And so now, activities in the patent office, getting a filing into the patent office really became, or has become, the important factor that you want to do as quickly as possible so that you can have a priority situation. And we'll go through that in more detail, but that's kind of the gist of that change. And it was a major change, and it also brought the U.S. into harmony with most of the rest of the world in terms of how they do priority in patent situations. And so it's been called for a long time by kind of the world patent community, and has actually now happened as of March of this year. The AIA also established new proceedings for post-grant review of patents. So after a patent is granted by the patent office, you can, either the patent owner or a third party can institute an administrative review of that patent by the Patent Trial and Appeal Board at the U.S. Patent Office. There's a number of different ways to do that. A little foreshadowing, I will be speaking right before lunch at some length on what those proceedings are, why you might use them, how they work, those kinds of things. There's quite a bit of subject matter there to talk about. So I'm not going to hit that in detail in this talk, but I will right before lunch. A couple of slightly smaller aspects of the AIA. The best mode defense has been eliminated. The best mode defense is the idea that if a patent issues and there's no description of the best way of practicing the invention, meaning that it was concealed so that the inventor could keep the best version of the invention secret, if that's found to have happened in the past, that patent that's a defense to patent infringement, meaning that you can't enforce that patent against an infringer if you're found to have done that. That's been eliminated now from the law, primarily because it was something that was pled very often as a way to get discovery as to what the inventor was doing commercially, but very rarely proven and successful, and so it really kind of became a very inefficient thing in patent litigation to have to deal with. Prioritized examination is now available under the AIA. For an additional fee, you can accelerate the examination of your patent and reduce pendency of your patent application from a typical average of a little over 2 years, and for some technology areas, more likely to be 3 or 4 years that you'd be waiting for your patent to issue from the patent office. With prioritized examination, by paying an additional fee, you can get that down to 1 year. And so that's, for industries in particular where the pendency is traditionally quite long, that's an attractive thing to do for important inventions. Prior user rights, I have kind of a separate slide on that, so I think I'll just talk about it at that point. And a couple other smaller things. Deceptive intent was something that was to make certain changes to patent applications, you had to show that or make a statement that there was no deceptive intent. That's been removed from most of the rules at this point. And the assignee now is able to file a patent application under their own name, which in the past patent applications had to be filed in the name of the inventors. So it gives the assignee, in some cases, a little bit more control over patent applications. So that's kind of what happened. Let's go through. I'm going to hit some of the bigger highlights in quite a bit more detail and talk about exactly what happened and the effect that has on how you do patent prosecution. Oh, one other set of changes that was kind of not exactly part of the AIA but came around a similar time was changes to the fee schedule at the U.S. Patent Office. And really the only one here that I want to talk about at any length is the micro-entity discount, which is a brand new thing in the Patent Office. Traditionally what we have is a set of fees that had a large entity tier for companies greater than 500 employees. Then there was a small entity tier below that for companies with less than 500 employees, nonprofit companies, educational institutions. They all qualified for a 50% discount in the government fees that are paid to the Patent Office. Now there's a third category, which is this micro-entity category, which gets not just a 50% discount, but actually a 75% discount from that full large entity fee. And a micro-entity is, the definition is actually somewhat complicated. It's kind of surprisingly complicated when you look at all the detail they put into that. The gist of it is, if a patent application is filed by inventors that work for a university, that assign their rights to a university, that qualifies. So universities are kind of the big winners in the micro-entity situation. It does not apply to university foundations, though, and so for those who work with universities, it's you kind of really have to go through the detail of the definition of a microentity to qualify for that. And in fact, if there's good financial reasons for assigning rights to a foundation, the microentity discount might kind of pale in comparison to what those reasons are. So that will have to kind of be played out. It also applies to inventors, individual inventors, but only individual inventors who have gross income below a certain amount that is set in the statute, and who have been named on 4 or less patent applications previously. So we're literally really restricting who qualifies for this, other than, of course, universities who appear to have had a very successful lobby in this kind of legislation. Okay. Let's spend some time in a little bit of detail talking about first inventor to file as the new paradigm for evaluating priority of patent applications. As I said, this is really the most important change that we had. So priority now is determined based on the applicant's effective filing date of their patent application. That's the date that is important to look at. Effective filing date means that you're looking for the earliest priority date of a patent application. So if a patent application is filed, it can claim priority from an earlier filed patent application in some situations. If a foreign filing was made in another country less than a year before the US patent application is filed, you can get priority back to that foreign filing. Under the Paris Convention is how that is done. The other thing is if you file a US patent application and then later file a patent application that discloses the same subject matter, so you basically have the same description there, and you claim kind of variations of the invention or different aspects of the invention in that later filing, there's priority there as well, and so you get to reach back to an earlier filing. So you're basically looking for the earliest filing in a chain of filings, if there is a chain, to set this effective filing date. If, of course, there is no earlier case, this would just be the filing date of the patent application. So we'll start with that date. We then compare to that date the prior art, which is anything that has been in public use or a published document that has a date of public use or of publication prior to that effective filing date. So it's really a pretty simple comparison here. You're looking at a date that you know, which is your effective filing date, and another date that you know, which is the date of public use or of publication of a document. In the case of a document, it's a pretty simple thing in most scenarios. In the case of public use, of course, that's going to require a little bit of potentially record keeping or investigation to see when that occurred, particularly if you're looking at this kind of after the fact, after things have happened. So now we know what prior art is. Of course, prior art is the definition of kind of all the subject matter that a patent application has to be different from in order for a patent to be granted. So it has to be new compared to that information. It has to be non-obvious compared to that information. So prior art is a very important concept in patent law. And finally, there is a grace period in place, similar to the law that's been in the past in the US, for disclosures by the inventor that happened before a patent application was filed. So this prior art, you're looking for things that were done by someone else. If the inventor has done it, and it's within a year of the filing, there's a grace period where that doesn't count against you as prior art. So that is still the case. In addition, the AIA has kind of one unique thing about it in how they changed Section 102, in that if you have a public disclosure of some kind by the inventor, and it happens at a particular date, and then after that you have a publication or some kind of a public disclosure by a third party. So conflicting, they disclose kind of the same thing, okay, in this situation. Then the inventor files a patent application after this third party disclosure happens, but within a year of the inventor's own disclosure. Then that earlier inventor's disclosure serves to kind of remove that third party action as prior art because of this idea of a grace period, and there's an idea of being first to publish and then file within a year gives you priority under the AIA. So that's not typically how the rest of the world does it. It's pretty unique to US law. It's kind of based on this idea of a one-year grace period that we've had in the US for a long time that many other countries do not have. But it is kind of a wrinkle of the definition of prior art, and it actually becomes an exception to prior art. So this third-party document qualifies as prior art. It's called prior art, but it's removed by the earlier disclosure of the inventor in this case. So that's kind of the mechanics of how the new definition of prior art works and how priority is given to the first inventor to file. So just kind of a quick chart list pointing out the differences between the old version of 102, which defined what prior art is, and the new version. The The way that things used to work is that if somebody was before your filing date, a third party, you could overcome that prior art by showing you were the first to invent or first to conceive of your invention before that prior art came into being. You had to show that you diligently reduced the invention to practice after your conception in order for that to be done. That is now done away with, and now you can only overcome prior art if you were either the first to file, so you filed before it happened, or you were, as I mentioned just a minute ago, if you were the first to publicly disclose, publish, or sell your invention, and then you filed within 1 year. Patent applications that are filed now are prior art against everybody else's patent applications as of their filing date anywhere in the world. In the past, that was only a US filing that would give you this effect of prior art against other US patent applications. Now foreign filings as well give you that date of prior art effect against others. And the statutory bar that where you have this 1 year grace period was only applied to activities that you undertook in the United States under the old law. And again, the new law expands that to be anywhere in the world. So if you're an inventor, you publicly disclose your invention outside the United States, you have to file within a year in the United States to avoid being barred from that activity. So you only have 1 year of grace to file. So that really is kind of the main three differences between the old version of the law and the new. So this idea of being first to publish and then follow with a filing in a year, I've heard a lot of discussion since these new laws came out of whether it's a good strategy to rush to publish an invention that you have and then plan on filing a patent application within a year and cutting off all this third-party prior art for that intervening period. And my view on that is if you inherit a set of facts, if things have already happened and they are what they are at that point, certainly that's the analysis that you would do. You would look at what your filing date is, then you would look and see, okay, was there a publication before this that we can kind of reach back to have that beneficial effect? But for a number of reasons, if you are making your own facts, if you're proactively deciding what your situation is going to be, what your scenario is going to be, it's not a very good strategy to think of publishing first as a strategic action and then filing. Your first step should be, if you're preparing things in a way that they can be published, your first step really should be to prepare that as a patent filing. And there's a couple of reasons for that. The main one is that the subject matter that gives you this right to reach back to that earlier publication or to an earlier patent filing, or to any patent filing for that matter, requires that the invention be described in a particular way. The statute requires that the invention be enabled, which means that you have to teach someone of ordinary skill in your art how to make and use the invention. It has to satisfy that standard. And there also has to be a written description of the invention, which essentially means that you explain what about this technical subject matter is your invention. That has to be in there in some way. Those are things that as patent attorneys and as those of you who are writing patent documents are just kind of part of how we write things because we're used to that being the requirement. We're used to complying with those requirements. If you're writing something for a publication, there's no guarantee, and in fact, it's somewhat unlikely that those are going to be the things that are being taken into account. And so if those requirements are not met by the earlier publication, a later patent filing that now does have this description and has claims to what the invention is that are not supported by this earlier publication, you won't get that ability to reach back. You only get to reach back to things that describe the invention in that specific way. And so really, you might kind of end up in a situation where you don't have this ability to reach back that you think you do because of the way the invention was described. So you don't want to be in that situation. And the other is that a patent filing sets a date that cuts off this ability under the AIA to claim prior secret use as a defense to patent infringement. And I'll explain that in just a couple more slides, but the thing to remember is that a publication does not cut off that time, but a patent filing does. And in just a couple slides, I'll go through that in a little more detail. So the gist of it is a patent filing is always going to be better for you than a publication, and typically that's the way you should be thinking about how you establish a date, is let's get that filing date on the records and not use kind of this exception to prior art to reach back and remove things. Everybody recognizes potpourri, right? I have never actually heated potpourri to make a nice smell in any place, but apparently it's very nice. So here's a potpourri of AIA topics. Declarations under the AIA are different than they were before, and that seems like a very kind of minor thing. It's just the form that you use for the patent office changed. A declaration, for those of you who don't practice in this area all the time, is a statement by the inventor saying that I'm the first to invent this subject matter, it's my invention, and they sign at the bottom of that document basically stating that to be true. If you have a situation where you have a filing that happened before the AIA came into effect, this provision on September 16th, 2012, and then you have a continuing filing where you're claiming priority back to that earlier filing after the September 16th date. The way that the law typically worked was that you don't need to get a new signature on that declaration. You can just send a copy of the old one because the description of the invention is exactly the same. There's no new subject matter there. They just let you use that old copy. It's very convenient, specifically if that earlier filing had happened a long time ago. Because the declaration changed, the Patent Office made the decision that now you have to use the new form for any filing after, including if you're claiming priority to an old filing. So you may have a situation where inventors that signed a document many, many years ago you're now filing a continuing application, and where are those people, right? They maybe not with the company anymore. Who knows? People there's a pretty good chance that people are going to move around after any period of years happens. So it's not a bad idea for people who leave companies for contact information to be regularly kept up so that this is a more straightforward process of getting these documents signed. And it's not impossible to file if inventors can't be found for some reason, but it's more of a headache and it's time that you'd rather not spend if you could help it. Prioritized examination, I alluded to before. The fee is $4,000 for a large entity to file a priority exam case. Goes down to $2,000 for a small entity, $1,000 for a micro. One issue with priority exam is that actually, not so much one issue. One way you can use priority exams, if you have a case that was filed last year, for example, and it's related to computer software, and it's going to take a number of years for that patent application to be examined, because that's how long it takes in computer software. You can file a continuation of that case, call it a priority examination case, pay the fee, and get that thing done in less than a year. Really speed up the process for inventions that you know are important and would benefit from having a fast examination. One thing to be careful of here, this is where that declaration issue actually comes into play, because a priority exam case has to be filed with a signed declaration. Otherwise, it has a missing part and it can't qualify for priority exam. Your petition will actually be denied. So this brings up the case where if you were to file with your old declaration, like we all kind of got used to, a copy of the parent case's declaration, it would result in your priority exam petition being denied, and you'd have now a second slow track case going in front of the Patent Office, which is not what you intended at all. So things to remember here: make sure you file new declarations in all new filings that claim priority to old filings, And in priority exam cases, that's particularly important so that your petition will be granted. Prior user rights, I alluded to this just a bit ago. There's an amendment in the AIA to the infringement statute that gives secret prior users a defense to patent infringement. So let's try to think about what that might mean. If somebody gets a patent on a process of making computer chips, for example, and so that patent issues and comes out, and it turns out that a chip manufacturer has been using that process in their facilities for a number of years, but they've been doing it secretly because they've been keeping that technology as a trade secret because they wanted to gain the advantage that way. The new change to the infringement statute here would give that party, even though they hadn't created prior art because they haven't published anything, they haven't publicly used that process, they've just been using it secretly. As long as they've been using it secretly for more than a year before the effective filing date of the patent that came out, they have a defense to patent infringement. So it sounds like a really great thing for those who want to keep certain processes as a trade secret. One thing you should kind of use this defense, though, with some caution, because there's some limits to this defense. The transferability of this from company to company, even from facility to facility, is very limited. So if you want to expand that process to a new facility and think that you're going to just rely on your prior use rights based on a different facility, there's some questions as to whether that can actually be done. So that's a pretty significant limitation. If the asserted patent was patented by a university, this defense doesn't apply. So here come those universities again with some nice provisions for themselves. So again, I think here the risk-reward analysis for whether you should keep a process secret and gain competitive advantage that way, or whether you should disclose it and try to patent it and try to gain your competitive advantage that way, still needs to be made, with this defense only being kind of one factor of that. It doesn't just kind of decide the issue for you because of the risks of using it. Record keeping is a question I've heard a lot since the AIA came out, because of the fact that you can't rely on earlier dates of conception for priority of your invention. Traditionally, engineering notebooks were used quite a bit for that purpose, to show, okay, on a certain date, this inventor had this idea, they documented that idea, and here we have the record of it. We're going to submit that to show that we were the first to invent over some piece of prior art that came out that was later. So the intuitive view of that situation, now that that is not possible, is that, well, engineering notebooks are kind of obsolete now for this purpose. There's no reason to keep them with respect to patent activity. And in fact, there are still some good reasons to keep engineering notebooks. I have advised all of our clients to continue the practice of keeping dated engineering notebooks. I think the most important one has to do with the idea of derivation. So if you have conflicting two inventors that have the same general invention, one way that you can show that you have superior rights to that invention is to show that you were first and that the other party who's claiming to have invented it derived the information from you in some way. So you'll see that a lot in kind of joint development efforts where a company, typically a small company, will have an idea. A bigger company will come in and they'll kind of do the show and show them, hey, we've got this great thing. We'd really like you to invest in it and maybe partner with us in this and take advantage of the larger company's resources. And what a lot of times will happen then is the larger company might say, well, that's interesting, but it's not really quite exactly what we had in mind. And then something very similar might come out of their development efforts at some time later, and the small companies usually feel kind of like that was not fair. If you keep really good records of invention to show that you were first, and also records to show exactly what was disclosed to third parties when they come to see your inventions. That's really important for a derivation proceeding, where your contention is going to be that, hey, this third party that is saying they have this invention, they got that from us. We had it first. We were keeping it secret, and now they patented it, and they filed before us, but we had it first, and so they derived it from us. So again, those records are going to be important. Records of disclosures are extremely important, as they always have been, but they continue to be. So any activity that could result in what could be considered a public disclosure of some kind, or any commercial use of some kind, you need to keep records of those and keep them around, because they just, after the fact, come into play in so many things. And you want to show a record of use of technology, so that you can establish when your first date of use was, so that you have potentially access to this prior use defense against infringement. Talked about this a little bit ago. Under the AIA, a public disclosure anywhere in the world starts your 1-year bar as you're an inventor. And by third parties, a public disclosure anywhere in the world qualifies as prior art. So it's not just US disclosures or use, it's anywhere in the world now. And same thing for patent applications. The filing date of a patent application against the rest of the world as prior art, that filing date goes to any foreign filing in addition to just US filings. So that's an expansion of the AIA. So a quick summary of what I think the major things to take away from this discussion are: the best strategy for important inventions is still to file patent applications promptly as possible, not relying on publication as a strategy, but trying to get your filings to be first. For inventions that would benefit from fast issuance of a patent, priority examination is something that you don't have to meet any set of facts for. All you have to do is pay a fee. If you look at the cost-benefit analysis and that fee is worth it, priority exam makes a lot of sense. And the statistics from the Patent Office have shown that those cases are routinely getting handled in less than a year for a final disposition. So that is something to take advantage of if it fits financially. Continue to keep records of all your innovative activity and your use and your disclosures. Those are very useful things. And I also learned in preparing for this talk that AIA also, apparently if you're texting someone, that stands for appreciated in advance, which I can't, if I got a text that had that in it, do people who text things also then just have a link up all the time to like a lexicon of what these things mean? It's amazing how many acronyms there are. But since I'm going to be speaking right before lunch, I would AIA if you would stick around until then, and I'll talk to you at that point. Thanks very much. Appreciate it.